Our first presenter today is Skip Smith, who will be discussing space law in general and small satellite issues that companies can face. Skip is one of 16 space industry leaders and lawyers on the board of directors of the International Institute of Space Law. Skip has a doctorate in space law and has authored a number of leading publications, including a book, International Regulation of Satellite Communications. He is an adjunct professor of space law at the University of Colorado Law School. Before coming to Sherman and Howard, Skip held several significant space law leadership positions in the Air Force, including having served as both Director of Space Law at Space Command and Chief of Space Law at the Pentagon's Air Force Headquarters. Skip also served in Geneva as a legal advisor of the 50-person U.S. delegation at the ITU conference on the geostationary satellite orbit. Skip is a former chair of the Colorado Space Business Roundtable. At Sherman and Howard, Skip represents large and small companies involved in the space industry. In September, Skip received a Lifetime Achievement Award from the International Institute of Space Law at its annual awards dinner in Guadalajara, Mexico. With that, Skip.
All right, thanks, Kristen. So I think I'm starting my next lifetime now. And I want to welcome everybody. As I looked at the list of participants, there's many people out there I know, so thank you for listening in. We do have a diverse group of attendees. We have large companies like Boeing and Lockheed, medium and small company representatives, people from the insurance industry, engineers, media, people from academia, as well as students. So welcome to everybody. On behalf of our Space Law Practice Group, my co-chair of the Space Law Practice Group is Steve Smith, who many of you also know. Steve was the Vice President and General Counsel of Lockheed Martin Space Systems Company for over 15 years and has extensive knowledge on the private sector company involvement in space industry. We hope to have Steve with us in some future webinars, and we would like to continue doing webinars. This one's pretty high-level, big picture overview of international space law, national space law in the U.S., and then Dee Timmons, my partner, will talk about some commercial space activities, specifically what the government can and can't do, and I'll also talk a little bit about small satellites, which are one of the hot issues of space law today. So it is pretty high level. Let me get started. I can figure this out. Yes, here we are. So this slide is one way of looking at space law. There's an international aspect to it, which is mainly treaties, other international agreements, but also customary international law. And often we'll look to analogous international legal regimes like the law of the sea, sometimes air law. There's also a national space law aspect of this. Many nations have developed detailed national laws and regulations applicable to space activities. And then there's a third aspect to space law, and that's just your regular laws that are not space specific, but that are applied to space activities. Contracts, even torts, things like that. So that's one way of looking at the big picture of space law. This is another way of looking at it with international treaties, and particularly the space law treaties, really is the foundation. And I think it helps people who are involved in aerospace companies as they look at U.S. space law. It helps to understand why we have that, and a lot of that's driven by international space law, particularly the Outer Space Treaty. So this is another way of looking at how space law develops from international, national, and then all of your different legal regimes like government contracts. Most space companies have government contracts. They want government contracts. They also have private contracts. They have to worry about export control issues, intellectual property, insurance, resolution of disputes. All of these things are involved in space law. So this is what I'm going to review in the next about 20 minutes before I start talking about small satellite issues. And I may go over a little bit on this subject and then cut back a little bit on small satellite issues, see how the time goes here. So let's start with the major space treaties. All of these treaties, all 5 of these, came out of the UN Committee on the Peaceful Uses of Outer Space, UN COPUOS. They were approved by the UN General Assembly, and then they went to nations to sign them and become a party. The number in parenthesis is actually the number of parties. So you see the Outer Space Treaty has 104 nations that are parties to that treaty. Whereas on the bottom there, on the Moon Treaty, you only have 16 parties. All of these treaties and UN General Assembly resolutions, everything you could is available online. If you Google U.S. Or UN space treaties, it'll likely take you to the UN Office of Outer Space Affairs, where they have the treaties, the resolutions. They even have a collection of national space laws from various countries. So that's a very good website to keep in mind if you ever need to research any of the space laws. I'm going to start with the Outer Space Treaty. The Outer Space Treaty is often referred to as the Magna Carta of space law. It has broad general principles that are applicable to the exploration and use of outer space. Principles like freedom of use, non-appropriation, state responsibility and liability, the duty to consult. Now, many of those general principles were further defined in the subsequent treaties that you see: rescue and return, liability, and registration. So let's get to the Outer Space Treaty. I'm just going to focus on the key principles here, but there's a lot of them. The Outer Space Treaty is really an easy read, so I'd encourage you to pull it up and just read through it. It doesn't take long. This slide has 3 key principles: common benefits, freedom of use, non-appropriation. So the Outer Space Treaty declares that exploration of and use of outer space shall be carried on for the benefit and in the interest of all mankind. We refer to that as the common benefits principle. Outer space and celestial bodies are free for exploration and use. That's the freedom of use principle. Outer space and celestial bodies are not subject to national appropriation, and that's our non-appropriation principle. And as space law has developed, sometimes there's friction between some of these principles, like freedom of use and non-appropriation, which we see today when we discuss issues of asteroid mining, which I'll touch on briefly. Other principles include the peaceful use principle. The moon and celestial bodies shall be used exclusively for peaceful purposes. Well, what do we mean by peaceful? There's certainly many military uses of outer space. Those are peaceful uses. Generally, the way this is defined is this: unless you're using space for an act of aggression, it's a peaceful use. The next principle is that states are responsible for their national activities in outer space, whether they're carried on by governmental or non-governmental entities. This is the reason for much of the national space law in the United States and other countries. And this was a major compromise. Most of these treaties, the 2 key partners or the 2 key parties in negotiating these treaties were the United States and the Soviet Union. And in some respects, it was easier back then because there were those 2 main parties and their allies. But this was a major compromise. Soviet Union wanted only nations to be able to conduct space activities. The United States wanted other entities to conduct space activities. And thank goodness we have that, because we have a lot of entities conducting space activities now. Companies, multinational companies, etc. So this was a compromise. Other entities can conduct those activities, but the governments are responsible for them. And that's why we have fairly detailed licensing regimes in the U.S. and other countries. Next principles here we have non-appropriation principles. This is the state responsibility. Activities of non-governmental entities require authorization and supervision by the appropriate state. Okay. What's the appropriate state? Generally, the appropriate state is the launching state. And authorization typically means regulation and licensing requirements, as well as continuing supervision. States retain jurisdiction and control over their space objects. That's one reason you register your space objects, and thereafter you retain jurisdiction and control. States are liable for damage caused by their space objects. General principle stated in the Outer Space Treaty, expanded upon substantially in the Liability Convention that I'll get to in a minute. There's other principles in the Outer Space Treaty, and as I said, it's an easy read. So here we come back to the big picture of the treaties. We've talked about the Outer Space Treaty. Came out of the UN in 1967. A year later, you have the Agreement on the Rescue and Return of Astronauts and Space Objects. That was a big concern. What if we're launching astronauts into space? What if the astronauts return to the surface of the Earth under conditions of distress? Well, under this treaty, nations in which that space object might land are responsible to take all steps possible to rescue the personnel of the spacecraft and to return them promptly. Space objects are treated a little bit differently and less requirements there. If a space object that does not have astronauts or personnel in that spacecraft returns to your country, you would be required to take the steps practicable to recover that, and the obligations to return are less strict, and a state might, for example, say, well, we want you to cover our expenses in recovering this object. Liability Convention came out 4 years later, 1972. It's a fairly detailed and lengthy treaty. It establishes strict liability of a launching state for damages caused by space objects on the surface of the Earth or to aircraft in flight. And it establishes a fault liability regime in outer space. But the problem is we don't have any rules of the road in outer space. So how do you establish fault liability? Could be quite different. Claims go through diplomatic channels, and there's a claims commission if diplomatic channels don't work. We've never gotten to a claims commission yet. There's also the registration convention, came out in 1975, which requires launching states to have national registries and to report to the UN. Finally, there's the Moon Treaty. This applies to all celestial bodies, even though it's called the Moon Treaty. Only 16 nations have ratified it, and the main reason that the state or the space powers have not ratified this agreement is because of the international regime that it calls for to govern the exploitation of resources in outer space. This is kind of the big picture difference between the common benefits principle in the Outer Space Treaty and the common heritage of mankind principle in the Moon Treaty. See it in the Law of the Sea and some other areas of international law where under the common heritage of mankind principle, all nations should derive an equitable share of the benefits. The space powers generally haven't gone along with that. So very few members of the Moon Treaty. Now, there's a number of UN General Assembly principles relevant to outer space. I'm just going to talk about two of them. Because to me, I look at them as almost different sides of the same coin here. Under the direct broadcast satellite principles, satellites can broadcast television programs direct to your home. And many of the developing countries, and particularly countries in the Mideast, were concerned about that capability back in the early 80s, and they wanted the satellite operators to have the permission of the country in order to broadcast signals into that country. So it was kind of cultural sovereignty over the other position of this debate, which was freedom of use of outer space. No, we have freedom of use of outer space, so we can put up our DBS satellites and we can broadcast into your country. The way this came out after much debate was under these principles, you do need the permission of the nation before you can broadcast satellite signals into their homes, literally. Remote sensing came out a little bit different. Developing countries considered information on their resources to be really the same as their resources. We own it. We own the resources. We own the information. And developed countries, you shouldn't be able to sense our natural resources and take that information and use it against us. So it was really their sovereignty concerns about their resources, again, versus freedom of the use of outer space. We have the capability. It's a satellite. We're just going to sense your state. After much debate, this came out differently from the PBS principles. You don't need permission. You do need to make the data available to the sensed state on reasonable cost terms. There's a lot of other international law that's applicable to space activities. For satellite communications, you have the ITU Convention, Constitution, and radio regulations, very detailed. International Space Station agreements, because we're doing a lot of commercial business on the ISS. And you have organizations like European Space Agency, kind of our NASA equivalent, that are very important players. That's the international regime. Again, big picture overview. Now I'm going to spend 5 minutes or so on the national laws applicable to the use and exploration of outer space. Many countries have national laws. I have in front of me a book edited by Ram Jaku, who's now the director of the Institute of Air and Space Law at McGill, where I got my LLM and doctorate, and Ram taught me space law. But his book, which was published in 2010, covers domestic space law in Argentina, Australia, Brazil, Canada, France, Germany, India, Japan, Netherlands, China, South Africa, Russia, Ukraine, United Kingdom, and the U.S. And since then, there's been other countries that have come up with space law, like Luxembourg, which has developed legal and regulatory regimes in an effort to be attractive to companies to move there. And we've seen some companies, particularly those engaged that want to be engaged in asteroid mining, that have moved some of their operation to Luxembourg. Not quite a flag of convenience state, but it's got some benefits to states that are interested in space activities. You almost now, if you're a small company looking to do space activities, you may even want to have a comparative jurisdictional analysis done of all the national space laws to see if there's a particular area which may be more favorable to your particular space activities. Now let's talk about U.S. space law. We have the NASA Act in 1958. We have the Commercial Space Launch Act that came out in 1984. It's been amended a number of times. CSLA addressed three main areas. First of all, licensing and regulation of space activities, particularly launches. And then also liability and insurance requirements. And finally, access to government launch facilities by private launch companies. And pursuant to the CSLA and its regulations, the FAA regulates many of these activities: launches, return of space objects, spaceports, and it develops what a lot of you have heard about, the maximum probable loss for insurance purposes. monitors three-party waivers for launches. And so that came out in 1984, and 84 really was a big year for commercial activities in outer space, at least setting the groundwork for commercial activities to develop. We also saw the Land Remote Sensing Commercialization Act sought to commercialize Landsat. That didn't really work, and as you see on this slide, that was reversed with the Land Remote Sensing Policy Act of 1992, which returned Landsat to the public sector, allowed private firms to operate imaging satellites, and establish government regulation and restriction on those companies in the United States that put some of our early remote sensing companies at a significant disadvantage internationally. That's lessened in recent years. Inventions in Space Act really just says if you invent something in a U.S. registered space object, it's the same as inventing it in the United States. We have the Commercial Space Launch Competitiveness Act of 2015. Did several things. It extended the indemnification of U.S. launch providers for third-party losses through 2025. That was a big deal. Extended kind of the learning period applicable to suborbital launches, really, and space flight participants through 2025. And with respect to exploitation of resources in outer space, it allowed U.S. citizens to engage in the exploration and exploitation of space resources, such as asteroid mining. It did also declare that the United States did not assert sovereignty over celestial bodies. Next slide, we see a number of laws that are very important to space companies. Arms Export Control Act, we've got the ITAR. These are not really space laws, but they're laws that are very important to companies pursuing space activities. In the ITAR regime, lately in the last few years, we've seen amendments moving many items from the munitions list to the commerce control list. We have the FAR agency supplements that govern contracts for space companies, and we have state space laws. Colorado, for example, has a sales and use tax exemption for qualified property used in spaceflight. And we have state laws limiting liability of spacecraft operators, manufacturers, and their suppliers in Colorado, New Mexico, Florida, Virginia, Texas, California, I believe. So there's a number of states with laws that, to some extent, were there to promote spaceports within the state. We have release of liability forms called for in those state laws that apply to spaceflight participants. Despite the fairly detailed legal and regulatory regimes applicable to commercial space activities, there's still areas that are unregulated and that will require regulations to satisfy U.S. obligations under the Outer Space Treaty, such as satellites servicing spacecraft, asteroid mining. So we're still going to need to determine which agency is going to license and regulate such activities. There's a lot of hot issues in space law. So space debris is a big deal, space tourism. All these are significant. We're going to talk a little bit about small satellites and hosted payloads, and I'm going to, given my time, I'm going to need to move to that right away. So let's talk about small satellites. And in front of me I have a couple books on small satellites that I'll mention to you. One is called Small Satellites and the Regulation. It's by Ram Jaku and Joe Pelton, who many of you may know. Pretty good book, came out in 2014, addressing small satellites. And there's a book that came out in 2016 called Small Satellites, Regulatory Challenges and Changes, published by Nyhoff. I've got an article on this. So this is probably the most recent book on small satellites, and it covers a lot of small satellite issues in many of the countries that are active in that area. So a couple good books. Small satellites have drawn a lot of attention in recent years. It seems like there's a lot of conferences on small satellites, workshops, and in the 2015 session of the UN Committee on the Peaceful Uses of Outer Space Legal Subcommittee added a new agenda item on small satellites for 2016 and future sessions. So it's a developing area that calls for some special legal attention. First of all, what are small satellites? Generally, they're under 1,000 kilograms. Some people use it, it's 500, but let's say they're under 1,000 kilograms. We have CubeSats that are 10 centimeters by 10 centimeters by 10 centimeters, and we talk about 1 unit CubeSats or 3 units or 5 units, but they're small. Now we have even smaller ones, microsats and nanosats. Small satellites have a number of advantages. Because they're small and use less materials, you generally have a reduced price per satellite. And there's also reduced launch vehicle size and cost, and some additional options for launching your satellites. If you have a large communication satellite, the launch vehicles that can launch that are very limited, and some of them launch just 1 satellite at a time. Sometimes you'll get 2 satellites at a time, but large launch vehicles generally equal large costs. Smaller launch vehicles can equal smaller costs. Small satellites have the ability to function as hosted payloads. So it's really not a satellite in itself, but a small payload that lives its entire life with another satellite that hosts it. We'll talk about that at the end of this presentation. You have reduced technology risks generally because you have shorter life cycles. So your satellites may be going up for only a few years, and then you're replacing them. So technology can advance, which gives you shorter procurement times. And a lot of the small satellite systems we're seeing involve the use of constellations, sometimes of hundreds of satellites. There are some disadvantages to small satellites. Because they're small, they have less capabilities. They have smaller solar arrays, so less power, fewer communication options, and when you look at the cost per pound, they can be more expensive. There's a number of uses of small satellites. Scientific research. There's a lot of universities now just putting up CubeSats. It doesn't cost that much money, and it gets universities and their students actively involved in space activities. Remote sensing. You got a lot of small satellites out there for remote sensing. Several promising low Earth orbital constellations that are being looked at now. Communications. We've got broadband systems, some on the books, some being built like OneWeb, where you could have up to 650 small satellites providing broadband services around the world. And for these, some of these are going to be launched 30 satellites at a time, which is very interesting. Small satellites and U.S. law. Well, of course, the U.S. bears responsibility and liability for space objects that are launched by its nationals. Thus, we need licensing of small satellites. But although one might think that small satellites have a smaller legal and regulatory regime and challenges, that's not really so. Capabilities determine licensing requirements, not size. Your legal analysis really needs to start with what are my instruments and what are my capabilities aboard the satellite, and then you can decide. You can figure out where you need to go. If you're going to communicate with your satellite, you're going to need to get licensed by the FCC. You're also going to need, if it's going to be a remote sensing satellite, you're going to need to work through NOAA and get licensed by them. It's going to be launched, so somebody's going to need to get a launch license from the FAA. And when you're doing this, you need to be concerned about export control laws. Just talking with a foreign national could violate U.S. export control laws, so you have to be very careful in that arena. Space debris mitigation. Pretty much all licenses from all agencies require satellites to have and launch vehicles to have a space debris mitigation plan. Small satellites give you some more launch options, which is a good thing. You can have dedicated launch vehicles, and we've got dedicated launch vehicles in the U.S., Russia. You can also do what we refer to as a ride share. This is often a ride share on an ESPA ring, which is really a payload adapter it's a ring typically the size of the fairing on the launch vehicle, and it can kick out a number of satellites after it gets into outer space. SpaceX recently sold an entire Falcon 9 launch to spaceflight, which is serving as a payload aggregator. And so you may have a large launch vehicle, pretty large launch vehicle like the Falcon 9, that's going to launch. One launch is dedicated to lots of small satellites. There's certain legal challenges to adapt launch service agreements, which were typically used for the launch of 1 to 2 large satellites at a time, and accommodate the launching of many small satellites on one launch vehicle, and have some licensing, waiver, and insurance issues there that are particular to small satellites. This brings me to hosted payloads. So hosted payloads, you basically have a payload that shares a bus and a power supply with a larger satellite. Also have TT&C and certain other areas that will be shared. And these are different from other small satellites because the hosted payload remains with its host, in essence, for its entire lifetime. So this presents some unique legal challenges. But hosted payloads, I don't know, a few years ago it seemed like hosted payloads were the future of many space applications. We haven't seen them live up to the billing, so to speak. But they are a cost-effective access to orbit. Some operators have said they've been able to satisfy 80% of their requirements at 20% of their costs because they're sharing launch integration, the launch costs, and operational costs with the host payload. Generally, this gives you a decreased time for access. You can get a hosted payload very often on a launch. You can find a host for it and get a launch for it within 2 to 3 years versus many years for planning a dedicated payload that's going to be launched, one satellite per one launch vehicle. And in the last 4 or 5 years, I think this has been a government initiative, largely from SMC in Los Angeles. Again, I don't know that it's lived up to its billing per se, but I think in the future we'll probably see more small satellites go up in general, and certainly a fair share of those will probably be hosted payloads. But they do present some interesting legal issues, and you need to allocate these risks by contract. For example, what if the hosted payload is delivered late or not delivered at all? It's delivered so late that you're going to have to launch without it. Most contracts require the hosted payload entity to provide a dummy payload that can be slapped on to the host payload to compensate for the mass and other things you need to calculate for a launch. So you could provide the dummy payload and then it gets launched without the hosted payload. But what about the loss of operational revenue? Because the host satellite operator may have deleted a transponder or station keeping fuel to accommodate the hosted payload. So even if there's a dummy payload on there, so your launch calculations work out right, you may lose that revenue from the hosted payload paying you a certain amount per month or per quarter, per year, whatever, for the operation of the hosted payload. So you need to figure out how you're going to address that contractually. One option might be to require insurance to cover the loss of on-orbit revenue. Now what happens in orbit if there's problems with the hosted payload? What if the hosted payload starts interfering with the satellite or the satellite bus? It's drawing more power from the bus than it's supposed to draw. Those are things you need to, again, you need to address those risks in your contract up front and figure out how you're going to address them. And if you could also have interference by the host satellite with the hosted payload. You got to address those risks. And generally what you're going to do in all cases is the primary payload's going to have priority, but there may be financial consequences to the host payload operator if the host payload operator, for its reasons, has to turn off the hosted payload. Some of these can be covered by insurance, but there's really no standard form yet. So again, address these issues during contract negotiation, figure out how they can be managed. If they can't be managed, can they be insured? No standard terms and conditions that I'm aware of for hosted payloads. Each one is really unique, although, again, the general principle of doing no harm seems to be the primary legal principle in negotiating and drafting hosted payload agreements. So I have covered my subjects, and I now get to turn this over to Dee Timmons, and then we've left some time for Q&A at the end of this, but it's my pleasure to introduce Dee. Dee has been a government contracts guru his entire legal career, which spans over 40 years. He was a presidential appointee in the Department of Defense and served as Deputy General Counsel of the Air Force, where he provided advice on a wide variety of government space-related issues. He founded the Sherman and Howard Government Contracts Practice Group. How long ago was that, Dee? What year? In 1987. And Dee hired me when I got out of the Air Force. Dee is, he knows as much about government contracts as anybody I've ever met. He fights hard for his clients, and the one thing I can say about that is Dee is a Marine who won a Silver Star in Vietnam, and they don't give those out. So it's my pleasure to introduce Dee Timmons to talk about NASA support for commercial space activities.
Thank you, Skip. Good morning, everyone. I appreciate your participation. I'm going to discuss two areas this morning about doing business with NASA. The first area, I'll address the traditional avenues for doing business with NASA. They include contracts, grants, cooperative agreements, and unique to NASA, Space Act agreements. This second area involves the so-called commercialization of space resulting from the current national policies and prior federal statutes. Before I begin, we had a little national event last Tuesday that may result in some changes to NASA policy. I'm sure most of you are aware of the ongoing national discussion related to the changes the President-elect may make to President Obama's current policies. While I haven't heard anything specific as it relates to major changes to NASA programs, it certainly would be prudent to keep abreast of the scope of any changes that the new administration makes. As both President Obama and President-elect Trump have stated, major changes can occur with but a stroke of the pen. So in that regard, stay tuned. With regard to commercial opportunities, there are a vast array of opportunities for private entities to do business with NASA. NASA has statutory authority to award contracts, grants and cooperative agreements, and Space Act agreements. All of those agreements have their own either statutes or regulations or both that govern them. They are all different, and you need to be aware of, at the very least, the statutory provision and regulations that apply to each. With regard to contracting, NASA, like most federal agencies, awards contracts, and they are based in almost all cases on the availability of appropriated funds to fund a particular contract. They are typically awarded on a competitive basis as a result of the Competition and Contracting Act. From time to time, sole source awards are made by NASA. To award a sole source contract, NASA has to jump through a number of hoops simply because of the statutory preference for competitive awards. Contracts NASA contracts are statutorily authorized and are subject to the annual appropriations budget cycle. Most important for NASA contracts, like all other federal agencies that award contracts, they're subject to the Federal Acquisition Regulation. For those of you on this call that are familiar with the FAR, you all know it is about the size of a phone book. It covers virtually all aspects of the award of government contracts, and in the case of NASA, as with other large government agencies, NASA has a supplement to the Federal Acquisition Regulation. If you are going to do business with NASA pursuant to a contract, you need to be familiar with the applicable FAR and NASA FAR supplement provisions. If you are looking for business, you need to be familiar with the website at the bottom of the slide, FedBizOps. That website is managed by GSA, and it effectively provides notice of virtually all government contracting activities and possibilities. NASA is obligated by statute to publicize its awards on FedBizOps. It is fairly user-friendly. I certainly encourage you, if you're looking for business, to get familiar with FedBizOps. With regard to grants and cooperative agreements, NASA does from time to time award grants and cooperative agreements. I lump the two together because for most purposes, grants and cooperative agreements are very similar in nature. The OMB regulations that apply generally apply to both. If you're familiar with one, you almost necessarily can get familiar with the other. Typically, grants and cooperative agreements are awarded by NASA when there are mutual benefits both to the grant holder and cooperative agreement holder as well as NASA. There are numerous grants cooperative agreements that NASA awards, but again, the primary purpose of those two vehicles is mutual benefit. Space Act agreements are unique to NASA. The National Aeronautics and Space Act authorized Space Act agreements, and they have been and continue to be used for a very wide range of federal programs. The important thing about Space Act agreements from a monetary perspective is they are either reimbursable, non-reimbursable, or funded. And as the name suggests, reimbursable Space Act agreements provide for reimbursement of funds to holders of Space Act agreements. Non-reimbursable, you don't get any money, or some of them are actually funded by federal appropriated funds. Space Act agreements are not advertised on FedBizOpps. So if you're going to interest yourself in a Space Act agreement, you need to go on the applicable NASA website and pay attention to the various NASA operating facilities that may award a Space Act agreement. Space Act agreements are governed by NASA policy directives. The one cited on the slide is 1050.1L, and more importantly, NASA's Space Act Agreement Guide. The guide is managed by NASA's General Counsel's Office. It is a fairly user-friendly guide. It provides detailed information on the responsibilities of NASA as well as the Space Act agreement holder. Currently, NASA has more than 1,000 existing Space Act agreements. NASA is required by statute to update its existing Space Act agreements on an annual basis. You can get to it on the web, and if you simply peruse the current list of Space Act agreements, you'll find that NASA procures an astonishingly wide array of services through Space Act agreements. I'm going to move now to commercialization issues. And most of you know NASA's traditional focus has been and was using NASA personnel and facilities to move large national priority space programs. The two listed older folks on this call remember the Apollo lunar program, more recently the space shuttle. Both of those programs are unfortunately died and gone to heaven, so to speak. Orion is the ongoing program that is active, but traditionally NASA awarded large contracts to aerospace companies to design, build, and launch space vehicles, build the launch facilities, and provide engineering support to NASA. That focus, while it still remains alive and well, it has been changed relatively recently by the Commercial Space Launch Act. It, in effect, changes NASA focus to incentivize the commercial space industry in the United States. And in addition to fostering those changes, CLSA governs the sale of excess NASA launch facilities and services to commercial aerospace companies. You've seen that with a number of the private launch companies who launch out of NASA facilities, primarily on the East Coast. and CLSA governs those activities. It is U.S. policy reflected in the 2010 National Space Policy that President Obama signed in June 28, 2010, and the 2013 National Space Transportation Policy that was also signed by President Obama, that contains the policy statements related to the United States government refraining from competing with in the commercial space market. And both of those policies contain language that states, and I'll quote it from the 2010 policy, that the government, departments, and agencies shall refrain from conducting U.S. government space activities that preclude, discourage, or compete with U.S. commercial space activities, with two exceptions: unless that competition is required by national security or public safety. So that policy of non-governmental competition has provided commercial companies with significant inroads into commercial space, and has provided the basis for a major shift away from NASA running major programs to commercial entities running those programs. Pardon me. Importantly, if NASA provides facilities and personnel, CLSA permits NASA to recover only its direct cost. For those of you who are familiar with the FAR cost principles, there is a very specific set of regulations that apply to the recovery of direct cost. The CLSA requires the Secretary of Transportation to consider the commercial availability on reasonable terms of substantially equivalent launch property or launch services or reentry services from a domestic source, rather than going to a governmental source for those same services. Last but not least, CLSA doesn't permit NASA to use its government-owned facilities or personnel to compete with U.S. commercial companies that can provide equivalent services. There have been several recent examples of NASA having its own facilities that have competed with some of the large aerospace companies who have equivalent commercial services. Where are your business opportunities? If you are a small or large business and you want to get it, either increase your business activities with NASA, how do you do it? Comparatively small companies really have two avenues to do business with NASA. First is to explore FedBizOps, do your homework on the NASA various NASA directorates that do award contracts, grants, cooperative agreements, or Space Act agreements, in effect, do direct business with NASA. For smaller companies, an equally important way to go about it is to subcontract with established aerospace companies that have contracts, grants, cooperative agreements, and Space Act agreements. I noticed on the sign-up sheet for this presentation that at least two large aerospace companies have representatives on this call, both Boeing and Lockheed Martin. I know from past experience that both of those companies do a lot of contracting with small businesses for several different reasons, not the least of which is they may be able to do it a little bit better and cheaper, but if you have a government contract, you are required by statute to meet small business subcontracting goals in certain percentages. So those two areas two avenues are appropriate, but again, they are different in scope and size depending on what the nature of your business is. With regard to doing direct business with NASA, whether you do it by contract, cooperative agreement, or FAA, there are benefits and detriments that need to be considered. The potential benefits are, first and foremost, you have control of over your relationship with NASA. You don't have to go through a prime contractor in dealing with NASA. You do have a direct relationship. Second, you don't dilute your funds. Whatever contract or agreement you have with NASA, you'll get paid for it, and a prime contractor is not going to be taking out their share of those funds. Finally, you've got an opportunity to impress NASA with your expertise and capabilities without having to run it through a prime contractor. The flip side of the benefits are the detriments. And if you have a direct relationship, if you fail one way or another to meet your contractual obligations, the risk is going to be on you and nobody else. You also are responsible for complying with a myriad of applicable regulations and policies that are going to apply to your particular agreement. Familiarity with them, for example, the FAR or the NASA directives, is absolutely key to minimizing that risk. The second detriment is in not being able to deal directly with NASA. In that agreement, you may not be familiar with NASA's way of doing business. Having represented contractors with virtually all federal agencies over the years, you need to know of a particular agency's way of doing business, and the only way to gain that expertise is do it directly. Second area, as I mentioned before, is subcontracting with NASA. Prime contractors has potential benefits and detriments. First and foremost, if you're a subcontractor, you get to rely to a large extent on the prime contractor's prior experience with NASA. Your prime contractor, it's in their interest to make sure that you're aware of the required agreements, responsibilities as a subcontractor, and if you're a small business, most large businesses will in effect hold your hand. The other benefit is there are limited flow down requirements of applicable NASA regulations. Whether or not you're a contractor, a subcontractor, or a grantee or cooperative agreement holder, you're not hit with the full flow down, the full requirement of FAR clauses, and they are limited, but you need to be aware of what you're actually scoped with. Second, if you're not a prime contractor but a sub, you can negotiate the scope of your work tailored to your capabilities with your prime contractor. Potential detriments. Some prime contractors, quite frankly, can be difficult to work with. You need to vet your prime contractor if you want to be a sub, just like that prime contractor is going to vet you. In some cases, prime contractors, simply because they have bargaining power, they're not going to negotiate subcontract terms with you. You have to take it or leave it in some cases, and I would strongly urge you to be familiar with the T's and C's in a proposed subcontract. Second, our last issue is getting paid on time. Most prime contractors, if it's a FAR-covered contract, are subject to the Prompt Payment Act, so subs do get paid, but there are times and circumstances where prime contractors can withhold payment of funds for failure of a subcontractor to perform. So when you're entering into those contracts, make sure you pay particular provision to the payment terms. Well, our last slide is where to seek assistance. I could probably speak for the next hour on where to seek assistance, but I'm just going to give you 3 suggestions. One, if you're an existing small business under one of the existing SBA small business programs, the SBA has a fairly robust system of matching small business to prime contracting opportunities with the federal government. The SBA website is fairly user-friendly. I certainly would advise you to go to that website. Second, every federal agency, including NASA, has advocates for small business. They're called by different names, but every major procuring agency of the federal government has a small business advocate. You can get to NASA's Small Business Advocate on its website. I encourage you to go there because they may have done some of the homework you can use to match up your capabilities with NASA requirements. Last but not least, most of the large aerospace companies have outreach programs for small businesses. Those programs are in place primarily because those large contractors have small business goals that they have to meet in performing their contracts, and it is in those large companies' interest to find qualified small businesses, and they may be a valuable source of information for you. That's all the remarks I have this morning. I noted during my presentation that we've got a number of questions that have come in, so I'll turn it over to Skip.
Yeah, we have a lot of questions, and it's interesting because I know on the webinar out there, there are a lot of experts on many of the subject areas that we've covered, and I hope that in watering that down to get this done in an hour, we haven't made errors. But I do have one comment here that I'll come back to, and that is, it says, discussion with citizens or organizations from other nations is unobstructed by ITAR or other U.S. law when the purpose of the discussion is open technical standards. So that's a good point, that you don't, violate these laws when, by just talking to a foreign national. But I think the point I'd like to emphasize is you need to be careful. The large companies, they have experts there on, and their export and import side that will give you guidance if you are having discussions with foreign nationals. And there's a lot of companies that have foreign nationals in the company as employees. So there's a lot of issues there. I guess the main point is you need to be careful, and if you're going to be talking about that, run it by the right person.
Let me interject. There is no impediment to a U.S. company talking to a foreign national about business opportunities. The comment is correct. The area that you have to consider, however, when you're speaking with foreign nationals or foreign companies is whether or not you're going to have technical discussions with those companies and talk about what is known as controlled technology that is governed by the ITAR, the International Trade in Arms Regulation. Controlled technology, in a nutshell, is that technology that is related to items that are on the U.S. munitions list, an example of which would be specific satellite technology that is on the munitions list that may not be exported from the United States without an export license. That control technology related to that, say, satellite hardware, that control technology actually requires a license before it can be discussed with or provided to a foreign national. So there are, as Skip said, there are specific regulations, and you need to go to an expert in the field to make sure you're not unintentionally violating those requirements.
Okay, we also have a number of questions on small satellites and space debris issues. So I'm just going to pick one of these out, and that is, how will creation of small sat constellations with potentially hundreds of satellites impact the space debris problem? And I guess the short answer is it's not going to help. But all of the systems require licenses, and all of the licenses require a mitigation plan, and that's going to include things like deorbiting within 25 years. So most of these small satellites, I think most of them is correct, lack propulsion capabilities, and they may be able to point, but they don't have propulsion capabilities. So they're not going to go higher. You're not going to, boost them up into a graveyard orbit or something like that. You're going to have to rely on the atmospheric drag that we still have in low Earth orbit, LEO, removing them from orbit, hopefully within the 25-year criteria. Some of you are probably familiar with Don Kessler and the Kessler syndrome that is concerned with cascading collisions. You start with one or two collisions, and then you just have hundreds and thousands of pieces of debris which start cascading, and then you've got a gazillion pieces of debris and a particular orbit that you can no longer use. I mean, that's a concern, and that's why we have requirements for debris mitigation plans. But space debris is a real concern when you're talking about constellations with hundreds of satellites, and you're going to need to come up with a debris mitigation plan. Another question is, which treaties has the U.S. signed? That's an easy answer. We're parties to all of those 5 main UN space treaties except for the Moon Agreement. Let's see. And there's another question about on the small satellites and the debris side, and that involves damage. What's going to happen when a small satellite damages a larger, more valuable satellite? Well, they could be. Technically, they might be in same orbital planes, and that theoretically could happen. I don't think it's going to change the legal regime. It's still going to be, under the Liability Convention, a fault-based legal regime, and we've had a couple collisions so far in outer space. We haven't had any claims made under the liability treaty because of that, of those collisions, and I think that the reason is, how do you establish who's at fault? It wouldn't be just the satellite who was in space first. The regime isn't that way, where that's like in the ITU legal regime. Once you're registered, other satellites cannot cause you harmful interference. We don't really have that type of a rule of the road applicable to satellites other than in the communications aspect. So I don't know if the legal regime will mature and provide somebody with responsibility for collisions. Perhaps if there's one satellite that is capable of being maneuvered, it would have to maneuver to avoid a collision. We have the ability to monitor. We do conjunction analysis, and we have pretty good capabilities to figure out if there's a collision danger. That's handled presently by the U.S. Air Force. There's some talk of passing that down to another agency, maybe the FAA, or private companies, Space Data Association, et cetera, et cetera. But I hope that answers that question. Another question is, have other nations reacted to the 2015 U.S. legislation saying U.S. citizens may exploit space resources? I would say we've had surprisingly few protests from nations of that, and that's basically the U.S. saying, okay, U.S. citizens can do asteroid mining, things like that, bring those minerals back to the Earth or use them in outer space or whatever, and that is not an appropriation of outer space that violates the Outer Space Treaty. There's been some academics and policy wonks that have written some articles that violates the Outer Space Treaty, non-appropriation provisions. But the International Institute of Space Law, that I'm on the board of directors, we came out with a legal opinion shortly after that statute was passed, and our conclusion basically was that it did not violate the Outer Space Treaty. The other thing is you've got 16 parties to the Moon Treaty, which has even a more rigorous non-appropriation provisions. You have to have an international regime to govern the exploitation of resources. And there's been very few nations that are parties to the Moon Treaty that have protested in copious or otherwise the U.S. statute. So it's actually a little surprising that there hasn't been more adverse reaction to that, and I think that may show that we're on the way to acceptance of that principle that entities can take resources from outer space, kind of like fishing in the high seas. Let's see. Go ahead, Dave. Yeah,
I've got a question here. I have a small business that develops new technologies that NASA may have some use for. How do I get my technology to the appropriate NASA office for consideration? As we talked about earlier, do your homework online by researching the various NASA websites to identify potential NASA users. But an approach we haven't talked about is if you have a unique technology that's not otherwise available in the marketplace, you should consider submitting an unsolicited proposal to NASA. The Federal Acquisition Regulation, it's actually subpart 15-6 or .6, addresses the mechanism for submitting unsolicited proposals to the federal government, including NASA. And while submitting an unsolicited proposal doesn't guarantee contract award, at the very least your proposal would receive an initial review and an evaluation, and if it is truly unique product or service and there are funds available, NASA has the authority to award contracts based on an unsolicited proposal. If your unique product is not unique, there are other companies that can provide the same or similar services, then NASA is required to compete that requirement, and although you can participate in the competition, you obviously wouldn't necessarily win.
Let's see. Question is, can you further delineate the size breakdown after CubeSats? Is it our official maximum size on microsats and nanosats? The International Academy of Astronautics in 2005 proposed nomenclature, which has been somewhat widely adopted, but not universal. And their nomenclature is a category of mini satellites, which are less than 1,000 kilograms, microsatellites, which are less than 100, nanosatellites that are less than 10, and pico or pico satellites that are less than 1 kilogram. Let's see, you got a comment in here that maybe I was wrong on the small sats. I didn't mean to imply that all small sats lacked propulsion capabilities. So the comment is that many of them do. Of course, I know there's plenty of them that don't. And the other comment is that there's a lot of derelict objects out of there, space debris that are basically dead satellites that have much more mass than the small satellites that would be part of these constellations, and that therefore these small satellites, constellations, may be less of a likely to cause the Kessler syndrome than the large derelict satellites. And please don't understand me to say that the Kessler syndrome is necessarily something that's widely accepted as something that's going to happen in the future. But Don Kessler put that out there many years ago, and there's a lot of people that are still concerned about that potential. Dee, you got another question? And then I think we may need to call it because we're over our time already. But go ahead.
One of the participants kindly submitted a NASA website, and it's for the Small Business Innovative Research Program, SBIR, but the website is www.sbir.nasa.gov, and my educated guess is that website has information related to NASA's program, and for small businesses, certainly it would be a good resource of information for potential business opportunities.
Well, so we're going to end it, but we still have a lot of questions that we haven't gotten to. If anybody wants to shoot me an email, feel free to do that, msmith@shermanhoward.com. Thank you for participating. I would like to get some feedback. This has been very, big picture oriented. Are there other subjects out there that you might suggest that we would do a webinar on that would be, far narrower than what we've attempted to cover in this one webinar? So I'd appreciate any feedback you might have. Again, thank you for participating.